In the mid-1970s, we began to mandate the teaching of legal ethics. And it was also during that period of time that there was the Warren Court expansion of due process and the rights of criminal defendants. It's also true that the punitive approach that drives current policies emerged in the 1970s and 80s, where the primary theory of criminal justice shifted to the extent it had been rehabilitation, to retribution, and to crime control. And we've gone back and forth over the years as we talk about rehabilitation, retribution, and crime control. The RICO statute, the racketeering charges, that was drafted in 1970, and that was used extensively. And of course, then afterward, we have mandatory minimum sentences. So even though those changes fundamentally altered our criminal justice systems, many people will argue, of course, that the fundamentals are the same, that Black and brown, mostly young men of color, are charged and convicted of crimes in circumstances where we know now that there are ongoing wrongful convictions. And of course, we could name many cases, many jurisdictions from 1970 until today that demonstrate 2 steps forward, but at least 1 step backward. As we repeatedly say, we have more than 2 million people, 2.3 Americans are incarcerated in state and federal prisons and local jails. It's a 500% increase in the last 40 years, and there are more than 70 million Americans living with a criminal record. The rise, of course, in incarceration rates has not affected all communities equally. We know Blacks and Latinos collectively represent about 30% of the population or more, but account for nearly 60% of the prison population. But fast forward to today, as a culture, we now recognize the term mass incarceration, the existence of mass incarceration. We focused on wrongful convictions since at least the 90s. We focus on the role of prosecutors, the role of police, the role of defense lawyers as well. And in the last number of years, progressive prosecutors have been elected who are implementing new policies. And of course, we have holistic defense as well. DNA and forensics have had a significant effect. And as I said before about ethics rules, we talk about ethics rules and ethics decision-making in all law schools. So tonight's discussion is going to take us from our current system, and we want to ask about the future, where we're headed, not only criminal justice systems and criminal justice reform, but criminal justice ethics, which is, you could say, a subset of the overall issue of reform. We want to talk about ethics writ large, as well as talking about ethics rules. Basically, how do prosecutors and defense lawyers conduct themselves, or should they do so in the future, and what needs to change? Of course, as we were putting this together, we were joking about trying to prognosticate about the next 50 years. It's hard enough to prognosticate about next year, and it's quite daunting. So maybe as we go forward, we could think at least of the next 10 years, or maybe the next 20 years. And I'm so pleased we have excellent panelists who can reflect on where we've been, where we are now, and where we need to go in the next period of time. So the assumption for tonight's program is a hopeful future. That is to say, when we're looking to the future, we will at some point in our lives be beyond COVID. Courts will be open. Lawyers can see their clients. Prosecutors can interview witnesses and prepare their cases. So we're just assuming that we're going to be beyond COVID. So that is a hopeful note. And I also would like to assume, although who knows, that we'll also be beyond discovery disputes, which have consumed a great deal of our time, our energy, our scholarly work. Maybe that's wishful thinking, but that's also our hope. So we hope that we can move from real problems, you all who are on tonight, can move from real problems in your daily lives to imagining a future that's different and ask, what do we do? What needs to change? So now let me introduce our terrific panelists. So first of all, I'm doing this in alphabetical order. We're very fortunate to have April Frasier Kamara, who's currently the chair of the American Bar Association's Criminal Justice Section, which is behind her, as you can see. That is the unified voice of criminal justice. There are equal numbers of state and federal prosecutors, defenders, and judges, as well as academics. I'm a member of that and proud of the work that we do. and very pleased that April is such a visionary and thought leader in evaluating and implementing programs and policies to move forward to increase fairness within our criminal justice systems. She's the director of the National Association of Legal Aid and Defender Services, their legal service initiative, where she advances their goals and priorities through initiatives aimed at enhancing public defense. Previously, she worked on national reentry programs as the reentry coordinator for PDS in DC, Public Defender Service, and also in the National Reentry Policy Reform at the American Bar Association in DC and the Legal Action Center in New York. She was a special assistant in the Juvenile Defender Unit in Shelby County Public Defender's Office, where she was responsible for implementing the Department of Justice's reforms and helping to build the first ever holistic and team-based juvenile defense practice. Welcome, April. Professor Angela Davis, Distinguished Professor of Law at American University Washington College of Law, is a nationally recognized expert in prosecution ethics, prosecutorial power, and racism in criminal justice system. She teaches a range of criminal law and criminal procedure courses, and previously served as director of DC Public Defender Services after years as a staff attorney representing indigent juveniles and adults. She's the author of Arbitrary Justice, The Power of the American Prosecutor, and Policing the Black Man, which you may have seen in bookstores and online. She's co-edited numerous books and is the author of many law review articles. Professor Davis is on the board of many human rights and criminal justice organizations and has one of the busiest speaking schedules of any person I know. So particular thanks to you, Angela, for joining us tonight. For members of the Hofstra community, you may recall Professor Davis's excellent presentation last year at the Lichtenstein Lecture on Prosecutorial Ethics in Current Times. Welcome, Angela. Thank you for joining us. Professor Bruce Green is the Lewis Stein Chair at Fordham Law School, where he directs the Lewis Stein Center for Law and Ethics. He teaches and he writes primarily in areas of legal ethics and criminal law, and has authored more influential articles on legal ethics and criminal justice systems than any scholar in the country. He consistently chairs state, local, and national bar association committees, including the ABA Criminal Justice Standards Committee. And for students who are on the MPRE drafting committee, no, you cannot ask him questions in the chat about the MPRE, but he is in charge of that committee. And he's a member and past chair of New York State Bar's Association Committee on Professional Ethics. He's also chaired previously the ABA Criminal Justice section that April now chairs. He served on the ABA Standing Committee on Ethics and Responsibility and was a reporter for several ABA commissions. Professor Green was a federal prosecutor in the Southern District of New York, where he served as chief appellate attorney, and he was the judicial law clerk to Justice Thurgood Marshall and Circuit Judge James Oaks. In May 2018, he received the Michael Frank Professional Responsibility Award given by the ABA Center on Professional Responsibility. Abby Smith. Abby Smith, welcome, Professor Smith. I have just lost your introduction somehow. How about that? No, let me pull it up. But I want to give you a formal introduction that somehow is no longer on my screen. So it's not here. But let me just say that Abby Smith runs the criminal defense and the prisoners clinic at Georgetown University Law School. She also is a prolific scholar. Her most recent book is Guilty People, and I want to encourage you to actually read that book. She and Monroe Friedman, after who this program is named, were very good friends, and they co-authored a book called Understanding Lawyers' Ethics. She's also written a book about one of her cases. It's very engaging, called Case of a Lifetime. And Abby, considering that I didn't look up your bio, that's not bad, right? You want to add anything? Oh, okay. So thank you all for being here. And I purposely decided it was important for you to hear, for the participants to hear about people's backgrounds, because we are really very fortunate to have the people tonight framing this discussion for us. So I want to start with this. April, you have looked at the criminal justice systems in state and federal courts across the country. So before we drill down and talk about ethics rules, Can you talk to us for a few minutes about what are the fundamental changes you believe necessary as we look forward in the next 10 years, 20 years, or whatever number for a fairer criminal justice system?
Thank you, Ellen. First of all, thank you for inviting me to join a panel of experts who I admire. I think the 21st century issue that we have to deal with in the criminal legal system is the issue of race. We don't talk about it enough. While we have made efforts over the last few decades to really examine the issue of race, I really think about as we near the month of November, as we close out 2020, I've really been reflecting on what this year has taught us. And I think one of the most telling issues that we've learned as a country around the issue of race is that how deeply entrenched issues of racism are in our country, but also how deeply divided we are. So I think the challenge for us as criminal law practitioners are to really, as we explore technically what ethics rules are and how we operate as a system, it's really time for us to pull back and examine the soul of a system that has been built on slavery and racism. And I think the challenge ahead of us in order to, in some way, preserve the integrity of this system, we have to be very honest about how it was built, how it disproportionately impacts communities of color, um, but also how we all have very different lived experiences with the criminal legal system based on our experience. And I think for me, what was, the racial unrest that we face now, and it was really the center of our summer months around the killing of George Floyd. One thing that really sticks out to me is the fact that it seemed like so many people were unaware of the suffering in the Black community and how the deep, long-seated issues with race and law enforcement that communities of color experience on a daily basis. So I think the challenge that is ahead of us is to really think about how do we as a system define a term that prosecutors really have owned around public safety. What does it mean to be safe as a Black person in America? What does it mean? What does public safety look like? And I think we have to find a way to encourage prosecutors and people who hold power in the system to reimagine those terms around justice and public safety in connection with the communities that are disproportionately impacted. So definitely the number one issue that I think faces us right now is to really respond. I think the bandage has been pulled off of the very deep wounds of racism in America. And now the question is, how will we respond?
Thank you, April. Angela, you've written about these things. So do you want to follow up on that? Because when we drill down, right, and prosecutors are paying attention and defense lawyers are paying attention to these issues, we're talking about things like charging decisions and bail and sentencing and post-conviction and pardons. So how does what April's suggesting get translated?
So I couldn't agree more with everything that April said. And as you know, I mean, I focus a lot on prosecutors and the tremendous power and discretion that they have in the system. And I think many of the problems that April identified have been caused or perpetuated by the abuse of prosecutorial discretion in ways that have produced racial disparities in our system. I'm not saying that it has been done intentionally, but the harm has been done. And so I very much agree with April's thoughts about how we have to sort of transform. The system needs to be transformed, not reformed. I hate the word reform. I don't know what that means anymore. We need to imagine a new criminal legal system, so we can put the word justice back in it. But if you're asking me specifically about, you were asking me specifically about charging, were you?
Well, a number of things: charging, bail, sentencing, post-conviction. It's like every aspect of our system is infused with race, right? So as the progressive prosecutors that you work with around the country, think about these issues. How do we translate reform into practice?
Well, I mean, I think very simply, the power that prosecutors have, right? They and they alone decide whether to charge and what the charges should be. And, you know, throughout history, prosecutors have used that discretion. They've decided to charge some, decided not to charge others. The standard is very low. It's probable cause, you know, more probable than not. So it's very easy for them to bring charges. It's also very easy for them to decline charges. They alone make that decision. And so, you know, historically, they've made the decision in ways that have produced disparities and that, quite frankly, have contributed to this awful mass incarceration we have with 2.2 million people in prisons and jails. And so many of the newly elected and now not so newly elected progressive prosecutors have decided to use that discretion in ways to try to transform the system, right? By not bringing charges in every single case. Right, by using their discretion to not charge. And quite frankly, you know, the ethical rules and particularly the standards for the prosecution function, the ABA standards for the prosecution function, allow that, right? I mean, the standards talk about how prosecutors are administrators of justice, right? If I can just even quote the standards for a minute, they talk about how the prosecutor, the primary duty of the prosecutor is to seek justice, not merely to convict. We know that the Supreme Court said as much in Berger versus United States. The prosecutor serves the public interest and should act with integrity and balanced judgment to increase public safety, both by pursuing appropriate criminal charges of appropriate severity and by exercising discretion to not pursue criminal charges in appropriate circumstances. And so, you know, that's sort of specifically in the ABA standards. There's more about prosecutors being not just case processors, but also problem solvers. And in the standards, standard 3-1.2, functions and duties of the prosecutor, section E, it talks about prosecutors. The prosecutor should seek to reform and improve the administration of criminal justice. And when inadequacies or injustices in the substantive or procedural law come to the prosecutor's attention, they should stimulate and support efforts for remedial action, right? And so what more of an injustice in our system than the issue that April raised, which is the unwarranted racial disparities in our system, where similarly situated people, by the way, both victims of crime and the accused, are treated differently, right? That Black and brown people are treated worse than their similarly situated white counterparts, whether they're victims or whether they are accused of crimes. And so prosecutors have, in my view, an ethical duty and responsibility, not under the model rules. The model rules don't require it, but the standards for the prosecution function, which of course are not mandatory, they're just guidelines, but they're very important because they infuse that responsibility to prosecutors. And I think, you know, the progressive prosecutors who are trying to do just that, who are being criticized, many of them, right, for not charging, you know, and for declining charges, you know, people accusing them and saying they can't do that. Well, look, the ABA says they can, and the ABA says they should. And so I think that's one way that prosecutors can use that power to try to transform this system.
Thank you. So Bruce, I want to turn to you for a second now that we've already drilled down into ethics rules. So as Angela points out, the ethics rules don't reflect many of these concerns. So can you do a little primer for us, like the history of the ethics rules, the role of the ethics rules, and the reasons for the limitations?
So do you want me to just focus on prosecutors or?
No, overall, because I'm going to ask Abby soon about defense lawyers and why we don't have better rules as well for effective assistance of counsel.
So do I have to go further back than the 19th century, or can I start there?
Start when we all were required to take ethics rules. How's that?
So You know, everybody on this call who's a lawyer, obviously, passed the MPRE or was grandfathered and didn't have to pass it, but is familiar with the rules of professional conduct. And so I don't know how much needs to be said, but I think what's important is that when you're talking about the behavior of either prosecutors or defense lawyers, it's not really governed so much by ethics rules. The purpose of the rule, they're called ethics rules, they're really called rules of professional conduct, and their purpose is discipline, right? They're the rules which, if you violate them, you can be, disbarred, suspended, reprimanded, or whatever. And they're not meant to cover the field in terms of lawyers' behavior. And so on the defense, and to a large degree, they're just codifying things that exist elsewhere. So on the defense side, defense attorneys have a client, and a whole mess of rules are governing the lawyer-client relationship. And one thing to keep in mind is that they're generally one-size-fits-all rules. There's not a code of professional conduct for defense lawyers or for capital defense lawyers versus other defense lawyers, or for defense lawyers versus civil litigators versus transactional lawyers. And so they're very general, and they're derived, if you're talking about the attorney-client relationship, from agency law that does go back to the 19th century. And they don't give a lot of specificity. So I think, on the defense side, the duty of competence is pretty important. But first of all, I hope that, my students, when they graduate, don't aim to be competent lawyers, minimally competent, and aim to be barely competent enough so that they don't get disciplined. And so if you want to talk about what's really good criminal defense lawyering or excellent defense lawyering, you're not going to look to rules of professional conduct. And, the rules address loyalty through the conflict rules and confidentiality and so forth. But these are principles that predated the rules, and where you're hoping that lawyers are going to do better than the minimum required by the rules. If you're a prosecutor, you don't have a flesh and blood client or a corporate client. You're largely standing in for the client in that you're a public officer who's making the decisions on behalf of the state or the government that flesh and blood clients ordinarily make in a representation. And so while in theory, you have a duty of competence and a duty to avoid conflicts of interest and all that stuff, they're not really so terribly important for you. The other set of rules for lawyers that are important for both prosecuting and defense lawyers are those that govern advocacy. And to a large degree, they're premised on law, or they're coextensive with law. And so, you can't present false testimony. Well, you don't need a rule to tell you that, because if you did it knowingly, at least, it would be perjury and it would be a crime. So to a large degree, the rules aren't going very far beyond what the law requires. And if you didn't have them, you'd have judicial decisions by courts that were telling you what to do anyway. And that's a large degree of what's codified. Now, there is a special rule for prosecutors, Rule 3.8, which I guess is something we can talk about. But to a large degree, it doesn't go very far beyond what the law requires. So as Angela pointed out, you can't indict without probable cause, or at least knowingly without probable cause. And that's basically it as far as prosecutorial discretion is concerned. So both Angela and April have talked about the importance of prosecutors exercising discretion in ways that are not racially disparate, among other things. You're not going to find a rule in the rules of professional conduct that governs that. Even the discovery rule was for a long time assumed by prosecutors, I think, to be basically coextensive with Brady. The ABA has interpreted it to go somewhat beyond Brady in some respects, but disciplinary authorities don't necessarily enforce it that way. And a number of state courts have interpreted it not to be go any further than Brady. So I guess what I would say is that to a large degree, what we expect of prosecutors and defense lawyers comes from other places. It's in law, it's in court decisions, it's in ABA standards that, as Angela points out, are not enforceable, but they do express the profession's idea of what good lawyering is, good defense lawyering and good prosecuting. It's in what good offices call upon their both defense side and prosecutorial side call upon their lawyers to do. It's what lawyers do as a matter of self-regulation. We can talk about some particular rules or whether rules are the right place to establish greater demands on lawyers. But I do think if we had this program in 1970 and we could accurately predict what would happen with respect to rules of professional conduct for prosecutors and defense lawyers in the intervening years from 1970 to 2020, if we were accurate, we wouldn't be predicting a whole hell of a lot of change. You know, there's a rule that was adopted to deal with prosecutors subpoenaing defense lawyers for evidence about their clients. There are some rules that Ellen and I were involved in pushing that deal with prosecutors' post-conviction obligations. But if you're talking about the kinds of things that Angela and April are alluding to, racial disparities or mass incarceration, you're not going to find much in the rules of professional conduct. And I have to say, by the way, since you mentioned, Ellen, that I'm chair of the ABA Standards Committee, that April has appointed a working group within the Standards Committee to look in particular at the entire set of standards from the point of view of racial equity. And you know, that's just getting off the ground. And I think that's a terrific initiative of April's in her role as chair of the ABA Criminal Justice Section. So let me stop there. You could, I'm sure you could add if you'd like.
That's okay. So by the way, I want to encourage people to use the chat room. Please put questions or comments in the chat and we will deal with them. So Bruce, I mean, for people whose eyes glaze over, those of us who are steeped in ethics rules, right, talk about these things, but I can imagine that many people on this call, their eyes glaze over at this, you know, explication of how we got here. But it just sounds like there's such a disconnect between the role of ethics rules and the real issues that we're trying to deal with. So I want Abby to comment perhaps on, so why don't we include these things in ethics rules? I mean, why are they so narrow? Why don't we deal with racial disparity? Why don't we deal with higher standards for taking a case beyond the charging stage, beyond probable cause? Because if Angela and April, if their points are, you know, their points are really well taken, we want some accountability, right? And if you're going to have rules that are supposed to hold people accountable and you have standards as to how people behave, and you want lawyers to read them, why shouldn't they reflect the real concerns? So that's my 2 cents. Abby?
Well, I think they should, but the American Bar Association has not always been the most forward-thinking institution, and that's who has authored the rules of professional conduct and even the standards for prosecutors and defense lawyers. And I think we should lean on them. I agree with everything my co-panelists have said about the centrality of race as an ethical issue in our criminal legal system. And I don't think we've begun to do enough to address that problem. The rules with regard to criminal defense lawyers, I think are also implicated in this. And though I like to think that, especially among the indigent criminal defense bar, because I think of my students and my postgraduate fellows, that's the only thing I would have added to my introduction, is that I co-direct a program called the E. Barrett Prettyman Fellowship Program at Georgetown, which is a fellowship program that trains young lawyers, recent postgraduates, who are committed to indigent criminal defense, to making a difference for poor people accused of crime. You know, when I think of those folks, there are problems that are long-standing and endemic to indigent criminal defense practice, having to do with not enough resources, too much volume. But there are also some problems with the rules. The 2 rules that guide criminal defense lawyers with regard to performance are Rule 1.1, competence. Even that word, competence, could there be a lower standard? I always teach my students that competence is not what we're aiming for. You know, and we're also not aiming for the kind of traditional millennial touchstone that everybody will get an award if they do the best they can do. No, it's not about us. Doing the best we can do is not the standard, especially not on behalf of poor people accused of crime. That's not how I teach or train my students and fellows. And then there's rule 1.3, diligence, which is defined as a lawyer shall act with reasonable diligence and promptness in representing a claim. Oh my Lord, could there be a lower standard? That's what we expect of the dry cleaner, that they be diligent and prompt, not of a lawyer representing a person facing loss of liberty, which is what criminal lawyers do on behalf of our clients. It's the weakest, most mamby-pamby standard for representing people who need counsel, who need access to justice more than anyone else. And let me just kind of, pivot back to the prosecutor's question. The standard of probable cause, I just want to make plain how low that is and where it comes from. And this, picks up from things that both Angela and April have said, but focuses more squarely on the police. Prosecutors only have to find that a person is probably guilty, which any good criminal defense lawyer at trial, at closing, rebuts, because it's such a low standard, it doesn't begin to approach proof beyond a reasonable doubt. Where do the prosecutors who make charging decisions get that from, though? Get a belief that a person is probably guilty? From the police. And I think good lawyers, ethical lawyers, have to understand the history of race and policing in this country. And prosecutors can't simply take a look at a police report or a Gerstein and make a decision based on that. I mean, there's plenty of data to suggest implicit bias in our police departments. Frankly, there's plenty of evidence of explicit bias. Prosecutors have to use some critical faculties in making these judgments. We prosecute way too many people in this country, and there is a disproportionate impact. And it's bad. It's bad for democracy. It's bad for us as a free society.
So I'm
Can
gonna,
I just follow up?
go, Angela.
Sorry.
No, so don't be sorry.
Can I just follow up on what Abby said about that probable cause standard? I mean, I just feel like what she said, I just want to emphasize it, because I think the problem is that the model rules, like the requirement of the prosecutor, is just the probable cause standard, right? So, model rule 3.8A, prosecutors shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause, as she said, like the lowest standard possible. Compare that to the standard. The standard says minimum requirements for filing and maintaining criminal charges, standard 3-4.3. A prosecutor should seek or file criminal charges only if the prosecutor reasonably believes that the charges are supported by probable cause, that admissible evidence will be sufficient to support conviction beyond a reasonable doubt, and that the decision to charge is in the interest of justice. What a difference between the two, right? And so I feel as if the rules ought to more reflect the standards. And one of the problems with the probable cause standard is because it is so easy to bring charges, prosecutors, some of them pile on charges, right? Because they can, because it's so easy to bring charges, knowing full well that they cannot prove those charges beyond a reasonable doubt, thereby giving them an advantage at the plea bargaining stage. Because if anybody who's facing, a long list of charges, even if they have a good defense, may be afraid to take the chance of going to trial, right? Going to trial is risky business. You never know what a jury is going to do. So you can see why even innocent people will take a plea sometimes, and sometimes they do, just to avoid, being convicted of everything at trial. That's not just, that's what's passing as justice in far too many courts across the country. So I really think that this whole notion of probable cause being the standard for charging is extremely problematic and really deserves some change, some transformation.
Can I chime in, Ellen?
Yes, go ahead.
So
Because the first time this is an issue. That's what you're going to talk about, right?
what's that?
It's not the first time this has been
No,
made.
whatever. So there's a great article from decades ago by Bennett Gershman about what standards should prosecutors actually use. And he argues for a standard at the other extreme, which we call moral certainty. Prosecutors as gatekeepers have a responsibility to make sure that innocent people are not wrongly convicted, whether by plea or by a jury verdict, and to make sure that, he argued, if you're not morally certain of guilt, you shouldn't go forward. I don't know any prosecutor who actually would apply that standard. But according to Cy Vance, when he filed a motion to dismiss the charges against Dominic Strauss-Kahn, he said his office uses the standard. The office itself has to be convinced beyond a reasonable doubt before they bring charges. And they have to have a case that they think they can win. They have to have a triable case. Now, if you ask defense lawyers in New York, they may not be convinced that that's a standard actually used by the Manhattan DA's office, but it's a way more rigorous standard than the probable cause standards toward the other end of the spectrum. I don't think, though, that you could persuade rulemakers to incorporate into a disciplinary rule the standard that prosecutors ought to be using, because there'd be so much debate. Were you convinced beyond a reasonable doubt? Were you not convinced beyond a reasonable doubt? And so there's always going to be a gap between whatever standard prosecutors, as a matter of self-regulation, think they ought to use, or that the non-enforceable standards, the ABA standards or whatever, are going to tell you ought to do, and what the disciplinary, and that's true with all disciplinary rules, they're always minimal, right? We are always hoping that lawyers aim higher, that defense lawyers are more than competent. The problem, I think, is when lawyers see as a signal that the rules are not incorporating this constitutional minimum, the floor below which if you go, you'll be punished, but are actually, that's the right standard of conduct. So, I don't think any prosecutor should say, I've got probable cause, I'm going to bring charges and use the incredible power of the state then to get leverage to get a guilty plea. I don't think that's right, but I think it has to be made, but what's always been interesting to me since I've been teaching this stuff for over 30 years is that there's no agreement among prosecutors about what the standard ought to be as a matter of self-regulation. I don't know that every lawyer, even in a given DA's office, will agree, much less that there's agreement among all 60 plus DA's offices in New York or whatever. So I think one thing that somebody can do, the organized bar, the District Attorneys Association, is try to have some conversation around this and figure out what is the right standard, because it's got to be more than probable cause.
But Bruce, this is not a new issue. What I thought you were going to talk about was when the bar was ABA, we're in the weeds here of the ABA and ethics, but there was a commission in the late 90s to revamp the ethics rules. And we ended up with something called Ethics 2000. And there was a wonderful proposal by a woman named Nikki Kukis to revise the rule for prosecutors and to have a higher standard. It doesn't have to be beyond a reasonable doubt, but it's got to be a lot higher than probable cause to take a case to trial, right? So you could have reasonable belief, but those proposals got shot down by prosecutors groups that did not want additional standards. So I know we're once again re-raising this question in the ABA criminal justice section, which is, shouldn't we have a higher standard to continue a case, not just to file it, to continue it? So I think the time is ripe, because we do, it's one thing to say the ethics, you make it almost seem like the ethics rules don't matter because they're really only for discipline, and what really matters are standards and what really matters are practice. But as I keep saying, if we want to have some accountability, I think Angela's right. We have to look to the standards and say, shouldn't these things become rules? I want to call on April, who wanted to talk about a comment that Abby made. Go ahead.
No, I think the comment that Bruce makes about ethics and how it relates to standards, we have to understand how important these standards are when we talk about transformation or dismantling the system. Because these standards, and I can give you an example of 6 years ago going into Shelby County, when there was an appetite for reform, to actually reform the system, the juvenile system, and they looked to ABA standards. And it is such a floor minimal that it makes it very hard on the ground when you're working in the trenches to actually achieve true reform based on ABA standards. Because technically, the ABA 10 principles around the delivery of public defense, it's just the bare minimal. And so it really has not responded to the call in communities for real change. And as a person that's looking to transform the system, we have to have these conversations about how oftentimes ABA standards are used as barriers towards change because it doesn't force local stakeholders to do more and to move the needle. So, I just wanted to talk about the reality of what the standards actually look like, even as we look forward in future years, as, we see the overwhelming majority of society is saying we need criminal justice reform. Well, what does that mean? And if we can't look to the standards to lead us towards that reform, what's going to be the benchmark?
Abby?
It's also a missed opportunity because law students have to take lawyers' ethics or professional responsibility. And these are called the rules. Yes, the standards are called the standards. The rules are model rules. They're supposed to be a model. Why would they be conceptualized as such a low standard if we really mean for there to be a model? And I just want to second the language choice. I agree that we shouldn't be talking about reform. We never talked about reforming slavery. We shouldn't be talking about reforming the criminal legal system. We should talk about transforming it. And, why shouldn't we aim a little bit higher in these rules? Now, I'm with you, Bruce. The rules are fairly easy to disregard. And I also feel a little cynical, even if the standard for prosecutors was moral certainty. I've never met a group of people more certain than prosecutors, frankly. Every day I meet yet another prosecutor who could not be more sure of themselves about the guilt of my client, no matter what the circumstance, no matter whether it's a single eyewitness identification case, no matter whether there are all the hallmarks of a false confession. The certainty knows no bounds. So that's a cultural problem, but maybe if it was in the model rules, we at least could teach folks to struggle with it. Now, I'm not suggesting that standard is just for prosecutors, but I'm reminded that Anthony Amsterdam, in his trial manuals for the defense of criminal cases, when he talks about what I think is the single most difficult ethical issue for criminal defense lawyers, and that's striking the right balance between client autonomy and lawyer responsibility in counseling, and maybe especially in counseling plea versus trial, he ultimately embraces a standard that's, at once kind of helpful, but also inscrutable. And that's that in the end, it's up to individual lawyer conscience, which I sort of describe as, can you live with yourself? Can you sleep at night? I want prosecutors to have to grapple on that same level. Is this the right thing? In a deep and broad way in view of what we know about our system of criminal law.
So I just to throw down the gauntlet a little bit, Abby. So I don't disagree with you, but it's not just the ABA that has the ability to make rules. As you point out, the ABA rules are just models, but every state in the District of Columbia, Puerto Rico, Guam, and the Virgin Islands all have rules of professional conduct. And at least you and Angela, I don't know about April, but the two of you are members of the DC Bar, I assume. The DC Bar actually has a slightly different rule than the probable cause rule, I believe. But one place to go is to your local bars. I mean, we can use the state ethics rules as laboratories of experimentation. And if you could persuade the DC Bar to raise the standard and then show that the world has not come to an end in DC and that the prosecutors can still function, that might be one way of influencing, the ABA. I do want to say, and this is in response to one.
Bruce,
No.
we're not allowed to go to any local bars during COVID.
Very funny. Well, bar association, shall we say? But
sorry, I couldn't help it.
That's okay. So of course you've completely derailed my train of thought, and I had the most profound comment to make too, but I'll pass the baton.
So I'm
Well,
sure
can
you
I,
remember it later, but speaking of profound comments, so on the Zoom is Eric Friedman, who is my colleague and one of the foremost death penalty experts in the country. And so Eric, I want to, if you could just tell us what do you think the implications are, the death penalty for the future of the justice system and these rules over the next 50, I mean, you can say 50 years, I'll say 10. Eric, can we get you on? Do I have to unmute you?
Yes, you have. Yes, thank you.
Go ahead.
And you have to, if you want to give me video, you got to start that too.
Okay, I'm happy to give you video. Judy, can you give him video? Here, choose virtual background. No. It's not working, Eric. Sorry.
Never mind. Never mind. I have such a great virtual background. I'm sorry you're missing it.
There you are.
Okay.
Okay, here you are. Okay.
I actually have more than 150 on my computer, but I won't distract you with that. I do want to answer your question, which is serious, because in the arc of the 50 years, the death penalty may have a lot to teach us. And I'm thinking this: it was dwindling in the late 60s, and there was an attempt to kill it off in the U.S. Supreme Court in 1972, which failed, and came soaring back. And by 1976, the Supreme Court had endorsed that. And one of the responses of the organized bar was to create, first time this had been done in a rare point in the criminal defense field, a specialized set of standards for capital defense lawyers, which of course are not rules, but are standards, and embody an idea of excellent representation that says what's good enough for ordinary cases is not good enough for capital defense, and writes in a lot of strongly written standards that, if followed in that field, certainly followed in others, would make people very happy. All right. Well, a couple of things. First of all, 50 years from now, the death penalty won't exist in the United States. That's a pretty good prediction based on political trends and others, regardless of legal things, costs, recognition of injustice, a lot of things. It probably won't. And as it dwindles out, the next attack is going to be on life without parole, for which the death penalty defense community bears a heavy moral responsibility, because one of the ways that it was achieved in the political process to reduce public support for the death penalty was to sell the idea that life without parole is good enough, will solve the future dangerousness problem, and so on. And therefore, I have said publicly many times that once the death penalty is abolished, every lawyer in that field should spend the rest of their professional life atoning for that sin by abolishing life without parole. Okay, well, if we're looking at the arc of the next 50 years, why should either death penalty or life without parole be covered by any kind of exceptionalism? After all, we all recognize that the things we complain about death penalty, race, innocence, poverty, horrendous upbringing, all those things that, of course, competent death penalty lawyers not only scream about, but are told that they must scream about. The ABA says so. Obviously, the first thing I say on the first day of my death penalty class is none of those things are unique to death penalty. And therefore, if we are, again, thinking about kind of the arc of history and moving from the abolition of the death penalty in part under the influence of all the fine high standards that we managed to impose on the lawyers in that field, and then towards not only the abolition of life without parole for adults, but before that, getting all the juveniles who are now entitled to rehearings out of life without parole, a field, a specialized field of its own, which has benefited deliberately by taking over the standards from the death penalty field. Good. So now, why don't we see if we can't build on, such progress has been made to date, and all the great progress that is going to be made before we all show up again for the next such conference 50 years from now, to see if
50 years from now, I don't think
to see if we can use use some of those lessons, and particularly the lesson of trying to get ABA standards, which are not rules, enforceable as much as possible as a practical matter. And many, to follow up on you, Bruce, many state bars in capital cases have adopted the ABA standards as part of their rules. Enforcement is another thing, but they have. And that leads to courts quoting them, using them. And in fact, when the death penalty guidelines were launched at Hofstra in the fall of 2003, Don Verrilli had just argued the previous June a pro bono death penalty case, which resulted in an opinion that quoted the ABA standards in such a way that you might think they were part of the Sixth Amendment of the United States Constitution. Right?
So Eric, I'm going to stop you there just for a minute, because I think the point is really well taken. And I just want to turn to April to see what if we look to the specificity of the death penalty standards, do you think as you look toward looking at race and standards that we could move in that direction? Is that a good idea?
I think the first thing that we have to do, and what our attempt to do with this project, is to look at the standards through a racial equity lens, and to really, in as much race, drives everything in the criminal legal system, so should our standards. They should reflect the reality of what's taking place in communities and within courthouses across America. So, we don't know exactly what that looks like, because when you talk about specificity, one of the challenges when we look at issues of race is that people can always point to neutrality as being not racist. And I think where we have to move within the criminal legal system is whether or not we're being anti-racist, because up to now, we've been very comfortable saying that the impact of the policies are race neutral, and that has been satisfactory to many stakeholders. And I think where we're going in the next generation of looking at race in the criminal legal system has to be centered around, how do you embed anti-racism in the ABA standards? What does that look like? We don't have a framework. We don't know exactly, when you talk about specificity, exactly what that is going to look like, but I'm confident that that's where we have to go.
Angela, you want to follow up?
One of the things I wanted to talk about was the rules. I agree with everything April said, and we haven't talked about this, and this may be going too far afield, but I think it's kind of important, is the enforceability or lack thereof of these rules, right? So you got all these rules, and I was just looking at the prosecutor's side. Can we count on one hand or half a hand the number of prosecutors who've actually been, not only referred to bar counsel, but actually, faced any kind of sanctions? And people are afraid to make referrals of prosecutors, even when there's a strong case. So if you have rules and they're not enforced because people aren't referring offending prosecutors when they violate those rules, then where are we? If you look at the stats on that, they're pretty horrible in terms of what is the mean? And even when people refer, the only person I can think of, and maybe there's been more than one, but I think of, I'm forgetting the name of the prosecutor in the Duke LaCrosse case. Nifong, right? Who was convicted, I guess is the word, for a Brady violation. But if you look at how that happened, right, the people who were the victims of his violation were young, wealthy, kids who could afford to hire the attorneys to do the investigation to discover the violation and all of that. And it was high publicity. But in the ordinary case, that simply does not happen. And so I think until we even get to the point where there's meaningful enforcement of the rules and a meaningful system, I'm not sure the rules are going to make that much difference.
And that, numbers of us, Angela, you, Bruce, I, Abby, have all written about this, right, over the years of lack of enforcement. But that's also true for ineffective assistance of counsel, right? I mean, it's not like defense lawyers who are doing a horrible job are getting disciplined either. And one of the comments raised in the chat, like, this is a little far afield, is should prosecutors have a responsibility to help raise money for defense counsel? I mean, that's one of the things some progressive prosecutors are doing, because if we're going to insist on competent counsel, there needs to be money. There need to be really good counsel in court. So I'm wondering, I'm going to switch to that just for a second. If you want to have race conscious or anti-racist standards, and anybody on the panel, would you include the role of the prosecution in securing funds for defense counsel?
Well, actually, Ellen, I think, and it was one comment in the chat about, will you even be able to recruit enough defense attorneys if the reality of the conditions that they work in do not allow them to meet ethical standards? But as opposed to holding the system accountable for underfunding public defense, you in turn punish the attorney who operates within the system. So I think as we have these conversations, it has to be connected to system delivery. And also it has to be connected to culture, because, there is a stark difference between what competence mean in Washington, D.C. versus different parts of the South. And I think so often it's not the rules that actually drive change within the system, but it's definitely the culture. And, it may be a bit far-fetched for this conversation, but having conversations about ethical standards in isolation of the reality of system deliveries and the fact that most public defender systems are in crisis, and that they are intentionally underfunded. And so even if we change ethical standards, if we don't recognize the reality of the system delivery failures that happen every day across America, I don't think we can move the needle.
Abby?
I agree that it's a system failure and that we should probably use words like ethics with regard to the system writ large. But I don't think it's simply a question of funding. I think there are choices to be made. And in my view, we prosecute too many petty offenses as misdemeanors, cases that do not need to be in the criminal legal system, partly because of the category of folks swept up, which includes basically the criminalization of a range of social problems. We have criminalized mental health problems, drug and alcohol dependency, and a host of other problems. If we didn't have so many arrests, and that's both a police and a prosecutorial responsibility, I think, we may well have enough lawyers then to provide better than competent representation, to provide devoted and zealous representation. But I think we're making really foolish, self-destructive choices on the front end. And look, hopefully we're coming out of a period when the rule of law has become more and more fragile. We have to have people buy into the legitimacy of the system in order for there to even be a rule of law. And I don't think we can do it when we prosecute so many people for so many truly foolish things.
So that being true, I mean, I think a lot of people are recognizing that we're moving towards systems of community policing, right? Which is to say, cases should not end up in the prosecutor's office. There should be some kind of community groups when there is a mental health problem to whom you send that person, right? And if we move in that direction, it's not the power of the prosecutor anymore, it's the power of the community. April, is that the kind of thing you're talking about when we're looking to standards?
Absolutely. I put in the chat menu, I completely agree with Abby, because the funding issue that we see is because I can give you an example. Abby knows, and Angela, DC Superior Court, like if you go into any courthouse, like the types of cases that we expend so many resources on within the criminal legal system is ridiculous. And if you had any system of failure at the failure rates that we have in our criminal legal system, but it continues to operate, continue to be funded, not questioned, not deeply examined. And I think we're presented now with an opportunity to reimagine or transform. And I'm going to borrow a word from Keir Bradford Gray, the chief defender in Philadelphia, about I don't even use the word criminal behavior because we determine what is considered criminal behavior. It's just behavior. But as a society, we determine what we consider to be criminal and not. And so we see issues around the difference between criminalizing behaviors in certain communities when it's not criminalized in other communities. And I'm a fan of having a conversation with the directly impacted communities about what they see as the solution. But that requires prosecutors and other system actors to share power with the community. So I'm going to talk about, it's not just about funding, but it's also about sharing power. And what does it look like for prosecutors to share power with communities? And have we examined in the communities that's mostly impacted what they see as the solutions for the behaviors that they see in their communities that other people may categorize as crimes? And that's a broader conversation, but we have to have it, especially as we look at this period of reform around policing. I'm really not a fan of us dumping additional resources into a system that has proven itself over and over and over again not to be effective in producing public safety for all communities. It only keeps certain communities safe, and that is unacceptable.
So anybody want to, I just wonder in terms of teaching, right? Because here we are law school professors, as we think about these issues, instead of teaching model rules of professional conduct, which I think we all agree are too low a standard, right? Maybe we ought to be teaching the standards. And Bruce, your MPRE drafting, maybe you ought to test people on standards instead of MPRE rules. I'm just throwing that out there as where we go in the future. I mean, why doesn't that make sense? We're all talking about need for standards. Eric Friedman's talking about how the capital defense standards change things, right? And that's, we ought to move in that direction. Now here we are talking about making the standards be anti-racist standards. So maybe law school really needs to change. Of course it needs to change, but maybe it can change in that regard as well.
So I do think there's a challenge here, and part of the challenge is actually whether you put it. I don't think you would put it in ethics rules, but wherever you want to put it, I think you have to describe the world that you want to see. And one question I have, so I remember looking, for example, at the 21 principles for 21st century prosecutors, which I think has been influential for progressive prosecutors. And you could ask the question, which of that stuff is about ethics? Probably very little. And which of it might be codified in standards, and where do you put it? And how much of it should be, what are we talking about? Just electing different prosecutors with different visions? Are we talking about legislation? I do think in some ways, the last place that all of this change is going to happen is in rules of professional conduct. You're talking about funding. I don't think funding is really a big issue for professional conduct rules. You're talking about prosecutorial discretion. I think you could argue that the probable cause standard is too low, but most of this is not going to be in an ethics rule. So how do you achieve if you close your eyes and say this is the world that I envision, how do you even describe it before you even figure out how you're going to allocate responsibility? What is legislative and what is, something else? I think that's a challenge. And I don't think the answer is rewriting the MPRE to, accomplish all this. No offense.
Yeah, Bruce, can I weigh in and give some recommendations to my friends in academia? I really think we're at a moment around movement lawyering. And as we train the next generation of attorneys or the next generation of prosecutors and defenders, what does it mean to share power with community? Right. And that's a different type of training than the traditional legal academic model, where oftentimes we're taught to be removed from community and not be authentic partners with community. So I definitely think there's space within legal academia in order to be relevant to where we are as a society and where we're going. Students have to be trained in movement lawyering. They have to be trained on understanding how these issues intersect with broader social movements. And so I think, in addition to teaching around abolition and transformation, and are those principles taught within law school classrooms? Because the law clerks that's coming to me, that's what they're asking about, and that's what they're interested in, because they understand that change cannot happen in isolation without community.
One second, I just want to step back for a second and say, for those of you who think the ABA is just a group of old white guys, right? April Frasier Kamara, right, is the leader now of the criminal justice section. So I just think it's just incredible, April, to hear you talk, to hear where we need to go, and think that that's something being considered by the ABA. So Angela and Abby, go ahead.
First of all, I couldn't agree more about April, and her leadership of the criminal justice section is truly phenomenal and groundbreaking, and I appreciate her leadership so much. But I wanted to say, and I know I keep saying I agree with April, but I agree with everything April says. I'm going to say it again. You're so right, April. Right now, movement lawyering at law schools is a conference. It's a conference, maybe at some law schools that care about those kinds of things. I mean, the law professors, the rest of us could talk to you about how hard it is to get anything done in law school. Go through the committee, and then argue it over it's crazy. And there's this thing called academic freedom. So like each professor has the right to teach what they want. But I tell you, I think that what you're saying is so incredibly important. And so one of the issues, for example, like the ethics course, your basic ethics course that every student is required to take, most of them, from my little informal, very unscientific survey that I did, do not focus on any criminal issues, period. Like it's mostly civil stuff. It's what happens to the civil lawyer. It's about fees, etc. Very few of them even talk about 3.8 or the rules that apply to defense attorneys, right? Which is why I took the lead of my fellow panelists here, Bruce and Ellen, and proposed a criminal justice ethics course. They've been doing this for years and finally got it through. And I teach that in my criminal justice ethics course. And I talk about race in all of my courses, my criminal, but most, I won't say most, a lot of them don't. And so until we get to a point where we were talking about reimagining and transforming, we really need to transform legal education, particularly when it comes to the criminal legal system. And that's I just want to agree with you, but also say it's going to be difficult, just simply because of how legal education works, how the curriculums are formed, etc. But I think we have to push for it. I really think we have to push for it. And alluding back to your initial comments about this horrible 2020 year, but it really has started to educate people finally, unfortunately, some for the first time, about these issues. And if there's any time to push on that, I think now is the time to do that.
Abby?
I couldn't agree more that the legal academy has been slow to embrace these ideas. But here's the thing, it's not a radical idea. The model rules of professional conduct in its preamble and scope describe lawyers as being a member of a legal profession, a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. Now, that last piece, the public citizen piece, I never used to teach that, frankly, before the Trump administration. But I've begun, every time I teach lawyers ethics, I begin by talking about the responsibility that lawyers have as public citizens. And the comments to the preamble go further in describing what's expected. As a public citizen, a lawyer should seek improvement of the law, access to the legal system, the administration of justice, and the quality of service rendered by the legal profession. So we do have an ethical responsibility. And this goes to something Bruce said about, is it ethics or is it more political? Is it legislation? It may be both. I don't think it has to be one or the other. I think funding of indigent criminal defense is an ethical issue. Frankly, that's another thing that I teach in the beginning of my ethics course, is that it's a kind of essential legal issue. The historical inadequacy of legal services to the poor in both civil and criminal cases is a problem, and it's an ethical issue, I think, for the legal profession. Now, that's not to suggest it's not complicated. It is complicated, and maybe we're not acknowledging enough how complicated it is. Movement lawyering, I love to teach that stuff, and I teach in Washington, D.C., and I run a clinic, and sometimes my students represent people who are directly engaged in the movement and who end up in the criminal legal system as political activists. That's complicated for criminal defense lawyers because, of course, as a matter of ethics, and I think it's the right approach, we represent individuals. We don't represent large groups or even movements. Now, I like to think of myself as better than an ally, which begins to sound sort of mamby-pamby to me too. I kind of like to think of myself as an accomplice to folks who are activists in the Black Lives Matter movement and other movements to transform our criminal legal system. But I also represent individuals, and I can't mount the revolution on the back of my individual clients. I don't think that's right. I don't think that that should be the responsibility of those particular clients. And likewise, I think I just need to acknowledge, and I know we all do acknowledge, and April kind of, suggested as much, that the criminal system, both over enforces and under enforces the law with regard to poor communities and communities of color. And, as we're talking about the criminalization of social problems, and that is something that I certainly harp on, I'm also mindful of the fact that, while I think it's insipid and kind of obscene to arrest and prosecute people on account of being poor or homeless when there's someplace they shouldn't be. On the other hand, sometimes there are businesses that are owned by, small businesses owned by people who are just trying to make a living, and they don't want my clients kind of messing that up and scaring folks off. I just don't think we need the criminal system to deal with that. And the under enforcement problem is deep. There was that fabulous book by, what was her name, about cold murder cases, especially cold murder cases involving victims who were Black and brown. Last name is Levy, or in Cal. I mean, there's most big city police departments don't do a very good job on behalf of some kinds of victims and do a much better job. That's what April's talking about when she says, some communities get better law enforcement and better protection, better public safety. So there is complexity there. I just want to acknowledge.
So I want to go back to this is really an important conversation, I think, but I want to go back to how do we move from the big change that's needed toward concrete ideas for, you're a well-intentioned prosecutor. You go work in a prosecutor's office, right? You are given certain perhaps guidelines, policies within your office. You want to be an anti-racist prosecutor, right? What do you do? What do you look to? How do you do that? We're going to look to standards. I mean, ethics rules. Abby's going to say you can't do it. We know Abby's position, but Abby's going to say don't be a prosecutor. But Angela, you don't think that. You think it's really important that people take those roles, right? We train really good students who try really hard, right? to make the system be more fair. And they can look to ethics rules. That's not very helpful, right? They can look to standards. Maybe that would be helpful for them if we change standards or moderated those. What do you say, Angela?
You know, I just think that because standards are standards, right? I mean, I don't want to just keep repeating the same thing over again. It's, you know, they're standards, and if they're not enforceable, I'm not sure that gets us anywhere.
Well, so do we think we should work on standards? I mean, you know, April's undertaken standards is a really critical piece because I think we acknowledge their role. And as Eric Friedman pointed out, you know, the Supreme Court cited them more than 50 times, right? And so we hope that they will have.
Maybe I'm wrong, you know, I hope I'm wrong, actually. It sounds like maybe I'm wrong. Maybe
I don't think you're wrong.
maybe standards are more, people are looking to them. I certainly hope so. But, you know,
No, I don't think so. I think most lawyers don't think about ethics rules particularly, and they don't think about standards. They think about practice, right? What goes on, as April points out, the culture. They don't want to certainly run afoul of ethics rules, but you know, they're very low standards, right? The ethics rules themselves, if you will. So, you know, if they don't really.
I have to chime in. It's one of my favorite Bette Midler lines. I have my standards. They're low, but I have my standards.
So, Angela, I'm sorry, I was asking you, like, what do you know, you have young prosecutor wants to do anti-racist work within a decent office. You know, you go work maybe for Larry Krasner or Kim Fox or Rachel Rollins, or there's like 10 new progressive prosecutors that have been elected, right?
right. So you're asking me, what do I tell the student?
Yeah, what would you tell them? I mean, what, you know, they want to be what they want to look to some force out there that would allow them to do the work that they think is important.
Well, I struggle with this, I won't say every day, but almost every day, because, you know, for me, I do a lot of counseling of students who want to be either prosecutors or public defenders. And it's one of my most favorite parts of my job. I love talking to students and counseling them. And I'm happy and delighted to say that for the past, I don't know, 3 or 4 years, every single student that has come to me saying they want to be a prosecutor has said, I want to be a prosecutor, but only if I can work for a progressive prosecutor. And that puts me in kind of a bind, because, you know, we're supposed to be helping our students get jobs, and there are only a handful of progressive prosecutors out there. And so, you know, to tell a student, you know, okay, you know, just go work for a progressive prosecutor is to say to them, you know, they're probably not going to get a job, because there's not that many prosecutors. Well, there's a whole lot of prosecutors out there calling themselves progressives. There's not a whole lot that really truly are. And so that puts me in a bind. So, because if that student goes to, you know, an office that has a traditional model of prosecution, I have to be realistic with them and say to them, look, you have to do what your boss tells you to do. You're going to be a beginning baby prosecutor, unless it's one of these offices where they just give full discretion to each. And I know this rule varies from prosecutor office to prosecutor office. There's some prosecutors that give more discretion to individual line prosecutors than others. There's others that have rules and policies that they expect everybody to follow, and there's stuff in between. But even in the offices that give a lot of discretion, if you're a baby prosecutor just starting out, you're probably not going to be able to come in there and just dismiss, you know, every case that comes before you that you think is not a dangerous crime, or dismiss cases when the cops violate the Fourth Amendment. You probably are not going to keep your job. And so it's a real sort of conundrum. I have a difficult time, which is why I'm doing my best to build that progressive prosecutor movement so that there are more of them out there who are doing this kind of work. Honestly, though, I don't know that there are many, if the even progressive ones, that are doing the true anti-racist work that April's talking about. I don't really know of any of that are really at that point yet, right? I greatly admire, you know, people like Kim Fox and Chesa Boudin, and, you know, and there are others that are out there that are really, Kim Gardner, for example, who doesn't get nearly enough attention in St. Louis, not Wesley Bell, but Kim Gardner in the city of St. Louis. And there are others, I don't want to start naming names, but the true sort of anti-racist work that April is talking about, even they, you know, are not there. And I'm not blaming them. I'm saying I've been looking at a lot of them who really struggle and really want to do the right thing, but coming into a system as entrenched as this and culture, April is right, it's all about culture. Coming and trying to transform an entire prosecutorial culture, even if you, the chief prosecutor, has that mindset, is more than a notion. And I don't care how strong you feel about it. I've seen it happen over and over again, the attacks that they face when they try to do that. I was foolish. I was one of those people that, all we need to do is just like elect the progressive prosecutor and they have all the power and they have all the discretion, so they'll just fix things. It's just not that simple. When you've got police unions pushing back, even judges who all of a sudden now have decided that, maybe prosecutors shouldn't have that much discretion after all, now that they're using it to try to transform the legal system. So there are all kinds of attacks, legal and otherwise. So I'm not trying to be negative. I'm just trying to say this is more complicated than I thought, as someone who's been working on this stuff for 25 years.
Well, like in the chat, someone says, well-intentioned prosecutors, you may train prosecutors on the rules, and the real world prosecution had draft complaints, evaluate witness and evidence, but that doesn't get to the fundamental questions, right? Yes, that's what Abby was talking about before, things that look neutral, or maybe it was April, I'm not sure, but really are not neutral. And many people would argue these days that even people like Kim Foxx, or whoever else is out there trying to change systems, you really can't do that. There's no such thing ultimately as a quote progressive prosecutor, better than others, but that we really need systemic change. So,
can I just put a pin in that though for a second? I don't want to say. I'm saying to get where April's talking about we should be, which is where I think we should be,
right,
is going to be hard. I do not, however, mean to minimize the really important and good work that has been done by a number of the progressive prosecutors, like Kim, like Chesa, like Kim Gardner and Kim Foxx. They are making a difference. I do think they're making a difference. I'm not one of these all or nothing people, right? All or nothing usually gets you nothing. So I'm forgetting something. And I do think that a number of progressive prosecutors out there are making a difference in their communities that is positive. It's just that I do push them and all of us to think, much further than that, rather than sort of tinkering within the system that we currently have.
And Ellen, I just wanted to weigh in because it's a lot of conversation about prosecutors, but I also want to challenge public defenders. One title you didn't throw into my intro is the co-founder of the Black Public Defender Association. We have work to do in our own defense community around anti-racism. And so BPDA, we are challenging our colleagues around the issue of race, because we have to be very honest about there are issues of race within the public defender community. And when we talk about legal issues around competence, we're challenging people to say, if you don't understand racism and the history of race, should you be representing Brown and Black communities? If you don't understand what it means to be anti-racist, should you be operating and representing people who are so directly impacted by systemic racism? And what does that mean for you as a public defender when you're doing individual cases? But should you have an obligation to also work towards the goal of anti-racism? Should we be partnering with people to do the systemic work around addressing the real issues that's driving people into our offices for services? Is there an obligation beyond just, providing competent representation? Do we have a responsibility as public defenders to be anti-racist and to dismantle systems of oppression for our communities? And those are the kind of, and it may never be in a standard, but it can be a part of our culture. And I think that's the responsibility that we have, specifically myself as a former Black defender, to push the public defender community around the issue of race, because honestly, a lot of public defenders are not comfortable standing up in court raising issues of race. It is a problem not just on the prosecution side, it's a problem in the defender community. And so when we talk about standards of, ethics and what it means to be competent, I would argue that if you don't understand racism in America, you should not be a public defender, and let people push back on that. But I think that is where we are. And we need to be very honest about what are the core competencies that you must have as a public defender to defend Black and Brown communities and all communities against a racist criminal legal system.
So we're talking about really, transforming law schools as well, April. As Angela points out how hard that is to do. But Bruce, you teach some of these issues, right? You teach an ethics and criminal advocacy course, and we all spent last summer, everybody on this call, putting together videos as a method to teach students, right? Trying to deal with some of these issues.
Well, I don't want to say I teach anything successfully, ethics, anti-racism, community prosecuting or anything. But I did benefit from having Abby, Ellen, and Angela participate in a fair number of discussions. But I would say I learn a lot from my students, honestly, about these issues. But they are hard to talk about. But I just want to push back a little bit because that's sort of what I'm trained to do.
That's
so
right.
For 30 plus years, I've been teaching legal ethics, and every time there's a crisis in society that involves lawyers, somebody says you need to do a better job of teaching legal ethics. It's like, okay, Watergate was my fault. Actually, that predated me, and Enron, and everything bad that happens. And so now it's like. DA's offices can't do the work. We have to train future baby prosecutors to do the anti-racist work. And I'm not saying we shouldn't train them. I'm just saying that can't be the answer, or a complete answer, or even a big part of the answer. I think the challenge for April is when you walk into the meeting of the criminal justice section and you have prosecutors and defense lawyers, I think a lot of this conversation is going to seem alien to them. They represent prosecutors and defense lawyers from all over the country, rural and urban, et cetera. And I kind of wonder, and you say, April, it's not even good enough to be a progressive prosecutor. You have to be an anti-racist prosecutor, which may not describe very many, if any, prosecutors out there. And now it's like, but the law professors have to do this work. Come on, my students. I always say, okay, I get them for 3 hours a week for 13 weeks. That's 39 hours. In the first week in the summer in the DA's office, they're there for more than 39 hours. By the time they get out, whatever work was being done in law school has been undone in 8 or 10 weeks. Now, and I would say the same about the PDS and public defenders' offices. So I'll turn it over to Angela because I saw she wants
to start somewhere. Come on, Bruce loves being the contrarian. We have to start somewhere. We all have some responsibility. Angela?
Well, that's kind of what I was gonna say, Ellen. I mean, first of all, Bruce, I will say most law professors are not qualified to teach this stuff. They're not qualified. They don't know how to teach students how to be an anti-racist. They don't. I mean, we're in my own law school, we're having our whole faculty go through implicit bias training, our whole staff, because we have a commitment to this at our law school. But this is hard work. I'm not trying to point the fingers and blame. I'm saying it's not happening anywhere. However, as Ellen just says, it's everybody's responsibility to build an anti-racist society, period. Not just in the criminal legal system, but everywhere. And so none of us get a pass. None of us get a pass. Law professors don't get a pass. Lawyers don't get a pass. Other teachers of other things, people who aren't teachers, everybody in our society should be committed to trying to build an anti-racist society in whatever way that they can. So I think we got to try. We got to do our part. As failed as it may be, as hard as it may be, we don't get a pass.
Abby?
And before Abby chimes in, I just wanted to say, I think if we truly are as bothered as most people said they were from the lynching of George Floyd, then we have to commit to radical changes within the system. And so whatever you've been doing, it may have been well intentioned, but it is not enough. And oftentimes, you know, an example was given by an advocate who is a formerly incarcerated person who gave the analogy of someone going through childbirth. He said he was in the room and he was supporting the person and saying, you know, you're doing a good job and trying to be as supportive as possible, but he could not even begin to respond or really truly feel the pain because he was not experiencing firsthand the pain of childbirth. And my point is, the reason I go back to movement lawyering, if you are not connected with the communities that are suffering at the hands of these injustices, then you're not equipped to be able to train people around the real solutions that's needed, that is in alignment with where the society is. And so the notion that we can just keep doing everything the same way and making these incremental gains, it's not consistent with who we say we are around wanting to be a country who truly advances racial equality. And the reality of it is this work is hard work and it will long exist when we're gone. It will never end, but it's necessary. And I just think I'm going to keep pushing for radical change, because what the incremental changes does nothing to appease the suffering of Black and Brown communities and people who are living these injustices every day.
So, and one of the first thing that needs to happen, April, is what you're starting, which is these conversations around the country, because what you're proposing is really not just radical, but new to a lot of people. I mean, if we started having these conversations, which we've started in larger law school communities, that would be one vehicle, right? If you started talking about this in the defense bar, which they've done, New York, this year I participated in the State Defenders Conference, which was a lot about movement lawyering. And should public defenders be movement lawyers? That wouldn't have happened years ago. So that's new. I would just say New York, this summer, we formed a law school anti-racist consortium, which has now 350 professors and administrators and students trying to figure out how do we transform law schools to make them anti-racist. And last week we had a program on changing the admissions process, with one of the suggestions being, let's look to people who are incarcerated, right? I mean, there are many people who are incarcerated. Why are we not admitting certain people who are incarcerated into law schools? That would change things. Why are we just looking at LSATs and GPAs? Why don't we interview people, for what people call perseverance in life? So there are many layers, of the law school piece that, it's like turning around a battleship, turning around a law school. Kim Fox always says, changing the prosecutor's office is turning around a battleship. It's all turning around a battleship, but I think it's really important that the conversations start. I mean, I had thought of this as moving toward standards and rules changes, but maybe we're just premature in thinking about that, and we need to have these broader conversations first. I like to anchor them, though, with this notion of standards and rules. Abby, shaking your head, yes? You're on mute. You're on mute.
Sorry about that. I had some barking dogs. I like everything everybody's saying. It feels like it's exactly the right aspiration. But sometimes I would just like people on the defense side to give a damn. And, do I need them to be as conscious of the history and persistence of racism? I just sometimes want them to give a damn that they stand between their client and a cage. And the systems of representation for indigent defense are, aim so low. I'm talking about systems throughout the country. It's not just in the Deep South. It's court appointment systems that, that accept low bids to do that work. Those folks just doesn't feel like they don't give a damn. On the other hand, I want to say, as a teacher and as a lawyer, caring and even consciousness is not necessarily enough. You need to do the work. You need to know what you're doing. And the rules then are kind of important. I don't, I do not think competence is a standard of any kind, and nor do I think diligence is. I can't believe that in the change from the code to the rules, we bury the word zeal somewhere in the comments. I mean, I think there's some things we could do concretely that would help us to teach that stuff. But I just want to put that out as well, that you want the whole picture. You want lawyers that understand anti-racism, that's true, but also that know what it means to be an excellent lawyer. And I just want to say, I do think that there are some prosecutors who aren't just talking the talk. I had an interesting conversation with Chesa Boudin about an issue that I think a progressive prosecutor ought to embrace, and it seems to me very few do, which is the use of peremptory challenges, which have been historically misused by prosecutors. They perpetuate jury exclusion, largely of Black people. And he said, and I'd like to know whether that's actually happening in San Francisco, he said that he was committed to having his lawyers in his prosecutor's office not employ peremptory challenges at all, to just rely on cause challenges. That would be huge. Now, of course, the rules of professional conduct don't go very far with regard to that. Rule 8.4, which is the kind of catch-all rule in the rules about misconduct, added a few years ago in 8.4F, a rule about, lawyers not engaging in discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, sexual orientation, gender identity, and so on. But then in the comment, it says, a trial judge's finding that peremptory challenges were exercised in a discriminatory basis does not alone establish a violation of paragraph G. So it kind of giveth and taketh away. And I just wanted to say one more thing while I have the floor, which is that, I wish I was more hopeful about the so-called so-called progressive prosecutorial movement. I mean, I have to say that my clinic at Georgetown, and people often hold up Washington, D.C. as a more enlightened jurisdiction than many, we have been doing only compassionate release petitions to try to get people out of prison during COVID. And we're focusing on older folks in prison and people with health problems. I can't begin to tell you how it seems to me that so few prosecutors and judges are apparently textualists, because they're not using the usual meaning of the word compassionate. They don't seem to have much compassion in, with regard to releasing people. Now, this is a time, and I'm depressed about it, because here's an opportunity to decarcerate. And we're really just going yet again for low-hanging fruit and are barely scratching the surface. For example, the DC jail numbers are back up kind of to where they were back in March and April. I don't really understand where the commitment is, and it has to be across the boards. And frankly, it has to include judges. And I've got some ethical concerns about judges as well. I just want to throw out there.
There's lots about the failure of compassionate release across systems. The number of lawyers we have spending their time filing these petitions and getting nowhere is shocking. And the number of people sitting in jail during COVID is shocking. April, you're on mute. You're on mute.
I think it's Angela, not me.
Oh, I'm sorry.
Okay, thanks. So first of all, Abby, one problem is that you don't have a progressive prosecutor in the District of Columbia. You don't have one, and you've never had one, except for Carl Racine, who's not prosecuting criminal cases. Carl Racine, who's the Attorney General, is doing great things with juveniles, but you don't have a progressive prosecutor. But I hear what you're saying. But I think, Gabby, what you're saying just to sort of remind me, going back to what Bruce was saying a long time ago when he was talking about how prosecutors don't represent clients. They just, as defense attorneys do, and why the rules are different and all that. But I'll go even further than that. I'll agree with that and maybe push it a little further and say, one of the problems is that the mindset of most prosecutors is really not what the Supreme Court said. I mean, I want to go back to Berger, versus United States. The very basics of what the role of the prosecutor is. The role of the prosecutor is not to seek convictions, it's to seek justice. I'm paraphrasing. And maybe sometimes seeking justice means seeking conviction, but sometimes, a lot of times, seeking justice means not charging at all. And all these rules and standards that we're talking about give them not only the right to do it, but the standards say that that's what they're supposed to be doing. And I think the problem is that prosecutors do still see themselves as seeking convictions or see themselves as representing. Let me back up a bit. When you're a prosecutor, particularly if you're an elected prosecutor of a particular jurisdiction, you represent your constituents, right? And your constituents consist of the victim of the crime, if there's a victim, the community as a whole. And of course, you have a safety, your duty to keep the community safe, but it also includes the defendant. The defendant is one of your constituents, right? So although you don't represent the victim as her lawyer or represent anybody as a lawyer, you represent that entire community. And you have this very difficult job, I don't envy it, of seeking justice for everybody and balancing it. And I don't think a lot of prosecutors see their role that way. I don't think they think like that, right? I think they still very much think about how they're there to lock people up. And the default is to lock people up. How many prosecutors ask their victim, what would you like? What would make you whole? What would make you heal? It might not be locking this person up forever. Maybe they want some kind of restitution. Maybe they want an apology if there's a restorative justice system. Maybe they want something else, but we don't give them, prosecutors don't give them another option. If they talk to them, it's about how much time, but there's no other option. And maybe that's not what victims want. Understand that today's victims is tomorrow's defendant is the next day's victims. A lot of people who come to the system are poor people who themselves have family members who are being prosecuted by the very same office, right? And so it's a complicated thing. And I think, again, there needs to be this shift in mindset about what the role of the prosecutor is. And that's something that's very basic. It doesn't require passing new laws. It requires sort of retraining and rethinking. And I have to say and give a shout out to the Jamila Hodge at Vera Institute, her Transforming Justice program, where they are actually in a number of these progressive prosecutor offices doing this kind of retraining of prosecutors at every level from the top all the way through to have them start to think about their rules differently. And so I do have hope, Abby. I mean, I do, because I do think there's some very good work being done. There's a lot to be done, but I point to the Vera Institute's work as a start. But I do have hope. I have to have hope.
I have to have hope in life, but I have to say, Angela, you point out one of the basic problems, which is prosecutors are elected. And you see even a change during COVID times, like Eric Gonzalez in Brooklyn, who had a gun policy. He wasn't going to necessarily prosecute people who had guns. There would be another program. Well, there's this hue and cry, and the feds decide, oh, he's not going to prosecute, we're going to prosecute. So you have the public. I mean, this is a bigger problem. It's just not the prosecutor, him or herself. You could have a really good prosecutor who's not getting reelected because the others, people don't like what's going on. So but I'm going
to have to push back on that. You're right. But I look at what happened to Kim Foxx and Kim Gardner, and there are no two prosecutors who have been spat upon and treated more horribly and, investigated by special prosecutors and, had death threats sent to them and continue to have people threatening their very lives for doing their work. But guess what? The people reelected both of them, right? So I know it's an imperfect system, but I think with the right kind of support and with the people speaking up, people elected these folks. They ran saying, I'm running on ending mass incarceration, and they got elected twice. So I'm not giving up hope. Tell me I have to, I'm not going to. So there.
How's that hopey changey thing working for you? No, I'm kidding. It's like,
yeah,
it's working.
I just wanted to kind of follow up about going back to public defenders, about training public defenders around, should we focus on traditional lawyering, what it means to be competent versus what does it mean to be anti-racist. And oftentimes I think about public health, because my husband works in that field, around whether or not, when we talk about training the next generation, if you were training medical doctors to go serve, to work in a community where 70 to 80% of the patients who come into the clinic have chronic conditions, but you train them just to be able to do the traditional examinations and do the traditional body scans in a traditional way that's targeted towards the general population without forcing them to specialize in chronic conditions, I don't think we would consider that a successful model. And that's what I'm arguing about the training of public defenders. For you to train them just to be good trial attorneys and not train them on the chronic conditions of racism in this country, you deliver them into a system designed for them to fail those communities. And so I will not stop at this traditional model of cross-examination, learn how to talk to, interview clients. No, you need to understand the systemic racism and the issues that plague those communities. So in addition to you getting a not guilty, you're also identifying the issues that you should be working in partnership with those communities to eradicate. And so that is a different type of public defender, but I'm confident that that traditional model of public defense has failed Black and Brown communities and it's no longer acceptable. So I feel strongly that if you're not anti-racist, you should not be doing public defense work, because we have to think about and really challenge ourselves to answer the critical question around whether or not we're actually doing harm. And I would argue, when you train to be a public defender and you focus on just being competent in trial skills and you don't understand race, you are doing harm, not only to Brown and Black communities, but to all communities who face the criminal legal system.
I couldn't agree more, but I want both. I want people who are anti-racist and know how to do the work as well. And I think in too many places, you don't get either.
I agree with you. I mean, one of the chat went back and forth on how great New York is, and I beg to differ. I mean, I know Scott Banks and Nassau running Nassau, maybe all their lawyers are really great, but there's just too many lawyers who are just don't give a damn and aren't all that good. And so we need to look at that as well. It's not, as you said, it's not just the South. And there needs to be, I think, some accountability for those defense lawyers as well. I know we started off by talking about rules and standards. And of course, as organizing this program, I had very specific rules we were going to cover. But frankly, I decided this conversation is a lot more important than looking at the particular rules. The last thing that I did want to talk about is going forward. There was a really interesting comment in the chat on something we wanted to cover, which is artificial intelligence. And one of the issues going forward is what's going to be the role of artificial intelligence in prosecution and defense. I don't know if anybody wants to comment on that. I know the comment in the chat, which is a little disturbing from everybody, looking at the role that the right wing has played in artificial intelligence. I'm looking for the comment again from Jonathan Lightfoot, I think it was, about the Algorithm Justice League and its efforts to address the use of technology, artificial intelligence, to promote white supremacy and enforce racist law and policy. So presumably we're going to see a lot of that as well. The criminal justice system, from the highest courts to the lowest police departments, are investing in these technologies to criminalize and incarcerate Black, Brown, and poor people. That's just part and parcel of the bail conversation that people have had about all the algorithms being used there. So I don't know, we're going to end soon. If anyone wanted to comment upon that in terms of where we go 10, 20, 50 years from now. Hopefully life is not going to be just about artificial intelligence.
Well, Ellen, I just it reminds me of Thurgood Marshall's speech to Howard University. I think it was his last speech before his death, about they're building traps for us that we can't even see. When he looked back at the civil rights movement and where we stood when he was near his transition. And I think one of the grave concerns I have about the reform movement is the fact that we accept things like artificial intelligence and even e-incarceration. So one of the dangers around the bail movement is that we want everybody to be home. But what does that mean to live in a surveillance state when, you know, the overwhelming majority of the community is on surveillance with cameras and e-incarceration and technology and how it's being used? So it is, and again, it comes back to the issue of if we don't address the underlying issue of race in America, we will reinvent incarceral systems that may look shinier and prettier and more humane, but they will still be rooted in racism and white supremacy. And that's the dangers of technology and artificial intelligence, that it does not account for and deal with the very systemic issues that surround the acceptance of, even if you are no longer physically incarcerated in a jail, we can incarcerate you in your home and we can surveil you. And who do we do it to? So it's complicated. But one of my greatest concerns is that in 20 or 30 years, we'll be having the same conversation about new incarceral systems that just look differently, but they still have the same frameworks of racism and white supremacy.
So not if you're in charge, April. So I think that's a great place to end, unless there's somebody else who wanted to add a comment. It's terrific. I'm glad you're hopeful, April. I mean, because it's incredible as you set forth, you know, Justice Marshall's last speech and what he said. You know, we could all look toward a system that's just going to reinvent other versions of what we have, but hopefully not. So anyway, thanks. It's been a terrific conversation. We are going to post it. People have asked in the chat whether we'll do so. I think it would be really helpful for others, for our students. I mean, this would be a great conversation, frankly, for a class for students to listen to. So thank you all so much. We really appreciate it. For everybody who's still remaining, we still have almost 60 people. We started off with almost 100. Thank you all so much for your participation. And good night, everybody. Have a good evening.